Good morning, everyone, and welcome. This is Leo Longo, and with me is my partner, Patrick Harrington. And today we're pleased to have you with us as we present our webinar concerning Bill 139 and how the new planning approval system might affect you and your practice and your lands. For this presentation, we're going to assume that people have a general understanding of Bill 139 and have at least read through it once. We're going to focus on 9 or 10 slides or themes, and from those slides carry on a discussion. Clearly what's new are draft regulations that had been published in December concerning transition matters and process matters, which will be discussed during our presentation. There is an opportunity for you to pose questions, and we urge you to do so. The likelihood of actually answering many of them will not be possible in this 1 hour. I'm pleased to say that our registration for this webinar is just under 1,000 attendees. So we're not going to be able to get through many, but we do hope to get through some. And we urge you to provide your questions, because it might then, once we review them, suggest what our next webinar content should be, following up on today's presentation. So with that introduction, I'll turn this matter over to Patrick to introduce the first slide.
So when we talk about Bill 139, of course, we're no longer talking about a bill. The bill has now become law, and the law is called the Building Better Communities and Conserving Watersheds Act of 2017. It received royal assent on December 12, 2017. For anyone who cares to look on the Ontario Legislature's page, there's perhaps a dozen or more Hansard extracts, meaning this bill went through a great deal of debate through first, second, and third reading and the committees. The bill itself comes into force, in fact, upon royal assent, but if you technically look at the bill, it's only about 3 paragraphs long. The meat of the bill is in the attached schedules, and each of the attached schedules makes changes to various acts. The 2 acts that Leo and I are going to be discussing today are the amendments, of course, to the Planning Act, as well as the new Local Planning Appeals Tribunal Act, which is going to replace the Ontario Municipal Board Act. And each of these schedules to the bill specify that they come into effect on proclamation. And proclamation is a date to be set by the Lieutenant Governor of Ontario, and that is a date that we don't know yet. Industry rumor is that they're targeting in the spring of 2018 for proclamation. The reason for the delay is that the province has to work on the regulations that go along with it, including transition, and we will have a discussion about transition, as well as some of the rules for the new Local Planning Appeals Tribunal. Many of the rules that are going to apply to this tribunal are going to be prescribed by regulation. So now that the Act is in force, or at least the bill was passed, the real work in getting the details ironed out has begun. The consultation periods for the regulations had ended, I think, earlier in January, but there's still a great deal of work to be done before they're ready to proclaim these changes into force. So what all of us have to be monitoring is, what is that proclamation date going to be?
And on that first slide, Patrick, just to note that it's clearly beyond the scope of this webinar to talk about what led up to Bill 139, the pressures that were placed on the government to seek a wholesale amendment to how appeals are handled, and the creation of a newly named tribunal, the LPAT, which continues the OMB members, but the Act itself, the OMB Act, has been repealed with a new Act. If people are interested in following some of the background, recent background of what the government had received, you should look at the Ontario Auditor General's report in 2017, which specifically looked at the OMB, its practice, its performance, and made some critical comments concerning timelines and functioning of the board. So commend that to people who want to get a little deeper into understanding what the province's own analysis was of the OMB's performance. With respect to the apprehension of what Bill 139 might mean to people, one need look no further than the actual number of appeals that have been recently filed with the OMB. For example, in the last 2 months of 2017, the OMB received over 600 appeals, and those 600 appeals will be in 460 files that the board has opened up. That's in the last 2 months, to indicate those people who are clearly trying to shelter their applications under the current process as we know it. City of Toronto, for example, has reported that since May of last year, over 140 appeals were filed with the OMB, as in the previous year, 2016, only 50 such appeals had been filed, representing a 180% increase in the amount of appeals. Moreover, the City of Toronto noted that based on the transition regulation as drafted, there are an additional 350 privately initiated development applications which could qualify for proceeding under the current regime should people file an appeal prior to proclamation, which would bring a total of applications under the old regime of 380. So there was clearly a significant apprehension by landowners to get their matters to the board for fear of what might be coming down the pipe with the new LPAT regulations and rules, which, as Patrick has indicated, we still don't yet have any final version of.
And of course, with that many appeals now in the system, as we talk about the new rules and regs and the new LPAT and the new appeal system, we've obviously got years of work and hearings and appeals to get through before the system fully transitions into the new tribunal regime. That many appeals and the limited resources the board/tribunal already has, notwithstanding the limited resources that municipalities have to process this avalanche of appeals, I think we're going to be dealing with the existing system for some time before we can say we've finally transitioned to the new regime.
The final thought on that is the board may, in essence, have a hearing schedule that has 2 tracks. One track will be devoted to clearing up all of the appeals that have been filed under the current OMB process, and another track might be dealing with LPAT appeals, which we understand will be the subject of timeline constraints as to when a hearing must be held and when a decision ought to be rendered. And it may be that the appeals that have been filed under the old Act might languish a bit more while the board is also trying to meet the timelines of new appeals before the new tribunal under the new Act.
So a bit of an administrative nightmare to come, but that was always a possibility when you're making such extreme changes to the existing regime. But of course, the next slide talks about some of the more in-depth changes in the appeals process themselves. You often hear in the press and in certain statements that the board is being abolished. That's not actually accurate. The board is being continued as the local planning appeal tribunal, which I think Leo took as a good thing, because Leo, as a historian of the board, can trace its lineages back about 100 years or so. So I think he was pleased to see that the OMB is still continued as opposed to just put to an end. One of the major differences that's coming with respect to the LPAT procedure is the idea that for certain appeals, official plan amendments, zoning bylaw amendments, and subdivision appeals, some of the major appeals that the board deals with, the submissions are not going to be in the nature of a trial. What's going to happen is that the record in front of the local planning authority or the upper tier planning authority is going to be provided to the board, and the submissions to the new tribunal, I have to start using tribunals instead of board, is going to be based on that record. You can see in the key takeaway, the first point below, hearings are going to look a lot more like applications or motions than trials, in particular that first level of appeal, and we'll get into the process in a moment. But it was our understanding from reading a lot of the background and articles written about Bill 139 that the Attorney General, the Ministry of the Attorney General, had in mind a transformation of this process into something less than a trial and more like an application or motion, where you have a completed record that gets put in front of the tribunal members, that you have time-limited submissions made by parties to the matter, and that the tribunal is to make a decision based on what was in front of council and based on the submissions that they hear. And you see in the slide that there is a proposal to limit submissions, 75 minutes for parties, 25 minutes for participants. Now, this obviously brings some questions about how do you administratively affect this. If I am a proponent and I've got 5 or 6 opponents at the board, do I get 75 minutes and each of them get 75 minutes? Conversely, if I'm a municipality, do I get my 75 minutes and then I can bring residents for party status that each get 75 minutes or 25 minutes for every participant? It's going to be on the new tribunal to weigh how these minutes are distributed amongst the parties, and maybe they decide to split them up, maybe they decide to impose greater time constraints, but it's certainly going to be a different way of receiving a party's case. The mandatory case management then becomes very important. Again, the Attorney General had in mind the pretrial conference format where parties attend in front of a judge and more or less give a preview of what the case is going to look like. And the judge is imbued with powers to make directions about how the matter will proceed in front of them. And obviously we currently do pre-hearing conferences in front of the Ontario Municipal Board, but as most of you know, some of those pre-hearing conferences amount to nothing more than taking attendance and updating the board on progress of negotiations. I think the idea behind mandatory case management here is going to be giving the tribunal members more power to direct matters and ensure that the matters proceed in a timely manner to meet the timelines that's setting out by the province. The board now is starting to require that parties have a completed procedural order, have a finalized issues list before they'll even give them hearing dates. I think you can expect that to continue, and I think you can also expect that tribunal members will be pushing parties to get to that stage so that the board can say that they're meeting their timelines. And when we talk about timelines, and we'll get into some of the suggested timelines, if you read the Auditor General's report, you'll see that the board has always tried to operate under internal timelines of about 6 months to a year to try to get these decisions turned around. But for reasons sometimes out of the board's control, where the parties want adjournments to negotiate, the time drags longer. Now with the province taking those kind of internal guidelines and imposing them through regulation, there's really going to be an impetus on the board to make parties push through the process, define their issues, and get to at least that first stage of hearing. And the ability to do that comes from that first stage of a hearing not looking like a trial, not having expert witnesses, not having cross-examination, but instead having the record assembled and having a lawyer or some other advocate come in and make a submission. The last point on that slide with respect to the Local Planning Appeals Support Center, and I think some members of the industry have started to get emails to ask for some input on that, but that's an idea that comes from some of the other tribunals in Ontario, like Human Rights Tribunal, Landlord-Tenant Board, where there is set up some resources at the door for persons coming in who want to participate in the process who don't necessarily have a good idea of how to do that. And so there's the idea of a duty council who might be able to guide them to, okay, if you want to be a party or a participant, here's what the expectations are, which is a good thing because now the board members don't have to worry about trying to do that in a pre-hearing. But also I think the support center is also proposed to have some qualified land use planners available so that participants and residents and stakeholders who don't have a firm understanding about what the project entails, what the as-of-right permissions are, they're going to be able to get a little bit of an education on that so they can go into the process a little bit more informed, or perhaps not necessarily needing to participate in the process if they have a better understanding about where things are going to go.
On that final point dealing with the support center, it's important to note that under the proposed act, which is Schedule 2 of Bill 139, not only does the support center educate the public as to the powers of LPAT and planning matters generally, but the support center can provide advice and representation at any actual hearing. That's the part I find quite interesting, to see how much of a budget this support center will be given and how active they will be involved in actual tribunal proceedings. I think the takeaway from this slide is to recognize that the adversarial system that we've presently had at the OMB is going to be replaced by a more inquisitional system where parties argue off a record, and the tribunal members will be asking more questions and perhaps taking a more active role in getting to the end result. LPAT members, I believe, will be given the discretion to extend the time limits that may be set out. We're not certain until we see the final regulation for sure. But it seems that a tribunal member will always have the ability, in order to make an informed decision, to ask the parties to bring evidence before the board. As to whether that would actually amount to calling viva voce evidence and permitting cross-examination, it might be a stretch when all the steps that have been taken to date seem to be suggesting we're supposed to be abandoning that process. So I can't imagine the tribunal in the first or second difficult case actually reverting to its old process. The optics of that might not be seen very kindly by the province and others. So we are into an entirely new area that will significantly affect how cases are presented, and as a result, you'll see as we go through other slides how private landowners might moderate or amend their usual MO in processing applications.
The other thing, before we just leave the slide, is one of the questions we were given before we started the webinar today, is what is going to be the role of the consultants in this new system? As it currently stands, if you're part of a consulting team, you're creating your reports, your planning justification report, engineering traffic impact study, you're submitting it to planning staff for review and processing. There may be revisions that get submitted with staff. The record is put in front of council with a staff recommendation. And then it goes up to the board if there's a disagreement or there's an appeal of a non-decision. And through the procedural order, we work out the timeline for the preparation of witness statements, which build upon some of the previous reports. And then the expectation is the authors of those witness statements are going to attend for examination and cross-examination. That latter half of the process is being cut out. So the idea here is that the consultant's role is going to be all up in the front of the process, that these reports are what ultimately gets filed with council is ultimately going to be what you rely on when you get to the board. So the importance of the consultant's work is up front in getting your planning justification, your TIS, and your engineering report in the best possible position it can be in when it gets submitted to council, because you're not going to get another shot at it. I had given a presentation on Bill 139 late last year at a planning consultants firm, just updating staff on what the changes were proposed to be. And when I gave that kind of presentation about you're going to have to front load your process and your reports are going to become even more important, the natural question was, can we charge more for them? But the reality is, those of you who can write a compelling report to support an application, that work is going to become so much more valuable in the next regime. And those whose skills are better put in the box in cross-examination, the need for that skill, I think, is going to become less and less. There will still be opportunities for cross-examination through the process, we believe, but it's certainly more of an emphasis on the upfront written work than it ever will be on the oral cross-examination skills that we're used to today.
Now, one of the significant changes introduced to the planning process through the new Tribunal Act is establishing a new test for what the tribunal will consider when dealing with an appeal of a municipally adopted official plan amendment, zoning bylaw amendment. And you see the three tests set out on the top half of this slide. This, in essence, means that planners will no longer be asked, does this represent good planning? Because that is no longer the test. Planners will no longer be asked about compatibility or adverse impact. What they'll be asked are the three questions that are set out on the top of the slide. And it would appear that it is only those three questions that will be determinative to the tribunal in making its decision. You can take the joint test.
Certainly. The joint test builds upon the new test. The new test is intended when there's a municipally initiated official plan or zoning bylaw amendment and there's an attempt to challenge that. The tribunal, when asked to hear an appeal, will assess whether those three tests are met. If it has, then it can go to the next stage. If it hasn't, then it's done. And I'll note that the Act has actually been amended to require that the tribunal engage in an early assessment in the nature of a motion to dismiss to figure out if this test has been met. The joint test builds upon the new test, and it's applicable where there's a private application. And what the private applicants will now have to satisfy is how the existing policies of the existing OP or zoning sought to be amended do not satisfy the new test, and how their application does satisfy the new test. And that's going to be, as we say in the next slide, a difficult standard to meet. A lot of the OPs that you're dealing with have gone through the process of ensuring conformity with provincial plans. They were obligated, especially in the Greater Golden Horseshoe, to bring them into conformity with the growth plan, and other OPs to bring into conformity with the 2014 PPS. To then stand in front of a tribunal and say, notwithstanding that this was updated for conformity, they didn't get it right, that's a difficult proposition. And it'll depend on how broadly or narrowly this test of conformity is going to be interpreted. And I think that's going to be the interesting thing when these decisions start to roll out. Because, as we all know, the wording of various provincial policies is intended to be broad because it has to apply to so many different scenarios, rural and urban contexts, inside and outside the Greater Golden Horseshoe. You can drive a Mack truck through some of those policies if you needed to, or it can be interpreted very narrowly such that you're never going to get a chance to say this offends provincial policy. The idea is to try to give more emphasis to the local planning, the local decision on whether it meets those tests, and there's still the standard of review of having regard for the decision of council. But the idea in imposing these tests was to make it a higher standard before the tribunal will think about, and I have to emphasize there's two stages here, so the first stage is only about whether they think about overturning the decision of council, particularly on private applications.
My own thought, not to sound overly optimistic on the issue of meeting the tests, is that the first test, is it consistent with the PPS, if we can go back to the previous slide, Patrick. That first test should be easy with the PPS. As Patrick has indicated, the PPS is so broad, and it actually has in it inherently opposite policies. Preserve good agricultural land, preserve good aggregate, and which one of those inconsistent policies applies to your facts was always the art of land use planning and making those judgment calls as to which policy in the PPS should prevail over another policy of the PPS. So because that's provincial-wide and the most generic, that one should be easy to meet. As you winnow it down, though, you then go to provincial plans, which clearly have a more defined geographic area, but even the growth plan for the Greater Golden Horseshoe must be read as a whole and has policies that can be seen to conflict with each other, so that there's some movement there to fashion a case that you meet the test. The third one perhaps may be the difficult one when it just deals with the upper tier municipality, which is obviously the smallest scale of application. Some upper tier plans are hundreds of sections long, and again might lend themselves to indicating that you conform to some but not to others, and allow you a foot in the door, as it were. So while there are just 3 tests, there's probably a lot of content in those 3 tests that would allow creative applicant to indicate that they do indeed meet those tests. But again, it's focusing the attention to those 3 issues and those 3 issues only that we will now be addressing. I'll go back.
Well, one of the interesting things about the joint test in particular for me is that it almost implies that you have to be able to show that the status quo doesn't meet provincial policy. And does that mean that the status quo, you have to prove that it's contrary to provincial policy, or do you only have to show that your private application better implements provincial policy than the status quo? And as we say on this slide, that's going to be easier to do where you have a very old zoning bylaw, as many municipalities continue to do. I'm not so sure you're going to be able to do that with more up-to-date planning instruments. And it'll be instructive to see what the initial decisions are as to whether or not on a private application all you need to show is an improvement over what exists today, or whether there's going to be more deference to the municipality's existing instruments to say, well, we think this implements provincial policy enough, and we don't see a need to, your marginal improvement isn't enough for us to overturn the decision of council. But
that may be wishful thinking, Patrick.
But the last point on the slide is also interesting, and it arises from a point that was made by a councillor at a Urban Land Institute presentation I had the good fortune of attending not too long ago, which is that if municipal staff choose to render an opinion on the new test or the joint test and offer it to council as a staff recommendation, it's going to become very hard for council to disagree with staff, because you've obviously got a proponent saying we believe we've met the test. You've got existing municipal staff saying we agree, we think they meet the test. How is council now going to turn around and say, well, we disagree? If they're going to go and then find some other opinion to support that, well, can they even do that, considering that the appeal to the board is to be based on the record that was already in front of municipal council? What does council end up having to rely on when their own staff says the test is met? And so the point that was made by the councillor, which is to say it's already difficult for a council to stick their neck out and disagree with their own staff. Her interpretation of the new act is that's going to become even more difficult. So a lot of power is now going to be vested in the staff who render these recommendations to council. And so there's a lot of incentive on applicants' part to work with staff to get the application in a good place where you can get that recommended approval.
So the added bad news about the new act, other than the fact that there are these new tests and the dual test, is that they've also changed the appeal process significantly. And it's one that we believe is actually quite detrimental to the stated purpose of trying to make planning applications be considered more expeditiously than they have been in the past. So Patrick, if you could take us through the flow chart, it would be appreciated.
So there's a lot more detail that goes to this, but we tried to simplify it as much as possible. You file your application, it gets processed to a staff recommendation, it goes to council, council makes a decision, you don't like it. You file your appeal to the new LPAT. Your appeal, after the Bill 73 amendments, has to fully disclose why you think your issue of consistency or conformity with the provincial policy. And the tribunal is empowered to dismiss, or in fact required to dismiss your appeal if you have not satisfied them that there is an issue under the new test or the joint test. If the tribunal, after holding the hearing, and we talked a bit about the new format of the first hearing, if the tribunal finds that you have met the new test or the joint test, whichever is applicable, the tribunal then sends the matter back down to council and asks council if they want to reconsider their position. The reconsideration period is shortened to about 90 days, and the next slide will talk a bit more about the timeframes. But it's up to council to decide whether or not they want to adjust their decision or render a new decision or keep the same decision and just let it be. Based on what council then does, the applicant then has an ability to file another appeal, which the Act now calls a second appeal. And on that second appeal, the same tests apply. But this time, if the tribunal is still of the opinion that the municipality has missed something on provincial policy or is refusing to implement some element of provincial policy, it's only on the second appeal that the tribunal itself is going to have the power to modify the OP or zoning to give effect to the appeal and correct the mistake that they believe is still being made by the municipality. And we believe that it's at that second level that the tribunal may be more empowered to hear evidence directly from experts and perhaps even some cross-examination, because they're going to have a basis on which to make that decision. And that second stage of appeal is probably going to look a little bit more like what we deal with today in front of the Ontario Municipal Board. But as you'll see from the next slide, it's going to take quite a while to get there.
Yeah. And as Patrick has indicated what he thinks the process might be on that second appeal, but the fact of the matter is the province in its materials haven't distinguished the time limit as being only applicable to the first appeal rather than the second appeal, as far as I understand. So in essence, the 75 minutes could apply to the second appeal when not only are you talking about whether the tests have been met, but actually trying to convince the board of the substance of the OPA and zoning bylaw that you're looking for. And I think that's a significant failing of setting up a two-part appeal process, but coming up with regulations that don't distinguish how much time one has on the first appeal versus the second appeal when you're actually dealing with the substantive matters.
The other issue that comes out of, if you read the Auditor General reports, is the idea of using multi-member panels. And there were questions put out by the province during consultation on Bill 139 to ask the industry, what do you think about multi-member panels? I don't know that there was a strong push for multi-member panels, but if you read the Auditor General's report, there is a belief, I believe, on the province's side that you can ensure greater objectivity on the part of the decision makers if you have more panel members. So one of the questions I have is whether, if you ultimately get to that second level of appeal, are you going to have a 2 or 3 member panel hearing that stage of the appeal? Will you have a 2 or 3 member panel hearing the first stage, or will it just be more like a motion to leave in front of a single judge? But there is a strong desire on the part of the ministry to use more multi-member panels because of the belief that they can assure more objectivity on the part of the members, which is a bit of a hue and cry that was coming from a lot of the residents who were opposed to the Ontario Municipal Board. Who's this person from outside our community who's coming in and subjectively just approving something that they don't have to live with? The province's solution to that is, okay, we'll put 2 or 3 members on the panel, and that way one person's opinion doesn't rule the day.
So turning to the actual timelines themselves that have now been placed in the Act, as you see from the screen, the time for municipality to consider a private official plan amendment has been increased from 180 days to 210, and similarly a zoning appeal from 120 days to 150 days, with the added notation that if the zoning bylaw is paired with an OPA, it defaults to the 210 days as well. So there's added time that has been provided to municipalities to consider complete applications. Remember, previous amendments to the Planning Act as well allow a municipality to seek mediation by itself prior to forwarding a record to the OMB, and that would add, I think, about 75 more days to the process at the local level before it gets to the OMB. And on reconsideration matters, the second appeals, as Patrick indicates, there's a 90-day time frame that's been established under the Act. Patrick, you can talk about what the province's anticipated expectations are concerning processing.
The draft regulations, or at least the summaries that have been made available by the province, have proposed certain timelines. And these timelines, I think, are meant to apply when the appeal record hits the desk of the new LPAT, that they are going to be able to process that appeal within the timeline shown in the slide. So for the larger OP and zoning bylaw appeals, they're aiming for a 10 to 12 month resolution period. If there's a second appeal from that there's a 6-month window to try to get that done. And for all other appeals, for example, your minor variances, your severances, your site plan, that is the timeline they're hoping for. There aren't any other real material changes to the appeals of site plan, to the appeals of severances, to the appeals of minor variances. A lot of those changes came in through Bill 73 in 2016. But this is one of the major changes that might apply to that, is this imposition of a timeline. And as Leo noted at the outset of the webinar, you might get parallel tracks needing to be set up at the LPAT, but the imposition, and it depends on how the province ultimately chooses to impose these types of timelines, if you're an LPAT member and you've got an appeal that has to meet a 6-month timeline, and you've got an old OMB appeal that has no timeline, you might actually see the newer appeal jumping the queue and needing to be resolved before the old OMB file. So it's not clear how that's going to be resolved through the internal processes of the LPAT OMB or through the regulations that the province is going to be impose. But also it's not clear from the regulations how the province even expects to enforce these timelines. You can see from the Auditor General's report that these types of timelines are the timelines that the board was already working with internally. They were trying to meet these deadlines, and for various reasons, some of which were out of their control, they couldn't necessarily meet them. Now the province is telling them they have to meet them, but they haven't really told them what's the penalty if you don't meet them. And the last bullet point about the TLAB, which is the Toronto Local Appeal Body, that's the body that Toronto has set up to hear minor variance and severance approvals just within the city. That process has a great emphasis on the timeline, and the timeline is set and fixed from the date of the appeal being filed, and the notice of hearing goes out setting out what your exact timeline is going to be. And it has resulted in what has been an efficient march into a hearing room, but there's mixed reviews about the front ending of the process and the requirement that your client have to produce all of the evidence they're going to rely on up front. It's kind of put a damper on settlement negotiations leading up to the hearing date, because clients are of the opinion, hey, I've spent all this money to get ready for a hearing, let's try our luck at a hearing. So I think the TLAB, to its credit, has committed itself to reviewing its rules within a year to fix what hasn't been working. I don't know what the province's willingness will be to review their rules and their timelines after the LPAT starts to ramp up their hearing process, what the willingness will be to change those rules if something's not working.
Patrick, we've already received a ton of questions, but some that deal with the subject we've just been speaking about, the tests involved. One question is, what is the impact of the new test, joint test, on minor variance appeals and site plan referrals, if any?
Well, the joint tests and the new tests are prescribed tests under Section 17, 22, and 34 of the Act. Those tests don't appear in Section 45, Section 41, Section 53. So those new joint tests don't apply in the case of those types of appeals. The test remains the same. The powers of the LPAT remain the same. What will change is the process once you get in front of the LPAT, and how the LPAT receives evidence and conducts its hearings.
And one finds that somewhat interesting, that for a minor variance or site plan, issues of compatibility, adverse impact, and what constitutes good planning, you'll apply those tests on something minor, but you won't apply those tests on a zoning bylaw. It seems somewhat odd.
Mm-hmm.
Another question that we have, which I think points to the difficulty in trying to satisfy the joint test question, when an existing bylaw is passed, it's deemed under Section 24 to conform to the official plan. So how could a private application for a zoning amendment ever meet the test when you have to say that the current zoning doesn't conform to the official plan?
I can say that that was an issue that was flagged by the OBA municipal law section, because it was believed that if it's deemed to conform, how could you ever say that it's not consistent or out of conformity with the OP? The later versions of the bill, as it got through committee, corrected that problem. And I forget the exact way it corrected. I think it was, for purposes of this section, it's not deemed to conform by virtue of Section 24. So that section doesn't actually apply for purposes of applying the test to a given application. That's how they resolved it. But it was in the first and second reading versions of the bill, and nobody could figure out how that was going to work.
Patrick, as we go to the next slide, I noticed one of the questions asked, Leo, how are you doing? I can answer that. I'm doing fine. Thank you very much for asking.
Nobody cares how I'm doing. The new restrictions on the ability to appeal, and this might be a way of answering some of the questions that are coming in about what has been affected, what hasn't been affected. Ministerial approvals of official plans, MCRs, and conformity exercises. The amendments to the Planning Act specify now that where the approval authority is the minister itself, when that minister decision is issued, it is not capable of being appealed. Now, that becomes very important when you consider things like 5-year reviews and municipal comprehensive reviews, because the delegated authority to finally approve something is removed in those cases. So for things like the City of Toronto, OPA 231, for example, or some of the major amendments to other region or county official plans, those that do have to go up to the minister for approval when there are those major undertakings. And the idea here is when the minister is going to be the one rendering the decision, there is no ability to challenge that. Now, you have to follow the bouncing ball through the changes that have occurred over the last 2 years. But one of the major changes through the growth plan, the 2017 growth plan, is that municipal comprehensive reviews, which is the only vehicle through which you can seek a conversion of employment lands to non-employment uses, those are now being undertaken at the upper tier level. and they're being done through conformity exercises, all of which is subject to ministerial approval. And if the minister approves it, there is no right of appeal. So which is why we say that you're going to shortly see the end of contested conversion cases. If you can't get the local or upper-tier municipality to agree to remove your lands from an employment designation, you're not going to be able to go to the LPAT and get them to do it for you.
But what that means, quite frankly, is that lobbyists at Queen's Park will have a whole bunch of new clientele who will be attempting to influence a provincial decision that deals with a upper tier plan that their clients aren't happy with. So there could be a whole bunch of lobbying behind the scenes, non-transparent kind of submissions being made to the province, recognizing that it's the province that will be making the last and final decision.
The section on major transit station areas would warrant an hour-long webinar in and of itself. We just note that the idea behind major transit station areas is an ability of a municipality to create an area of about 500 meters around a higher order transit, whether it be dedicated bus lanes, whether it be subways, whether it be GO train stations, and within that area prescribe things like minimum, maximum heights, densities, land uses, and in fact there are some minimums that they have to meet in order to create a major transit station area. Those major transit station area policies are subject to ministerial approval, but once they're in force and effect, not only can you not appeal their adoption, but you cannot seek to amend any of the policies within that area absent leave of council to pursue an application. The idea here is to provide a protected zone to achieve the intensification and density around a transit station that council in the province want to try to achieve. And that's why we call it a double-edged sword. If you're going to be able to get the density and height that you want as a proponent, it's a good thing because that's the idea. You're going to try to prescribe it as of right, and working closely with municipal staff and municipalities to get that major transit station area in a way that works for you is going to be very important. For ratepayers who are going to have to live next to it and don't necessarily want that type of density, your ability to say no has been greatly, greatly curtailed. Your ability to say no, in fact, is going to be limited to how quickly you can lobby your own councillor to say no to it. Because once these policies are in place, the idea is that they're not going to be changed unless the municipality decides to go along with the change.
And of course, the downside for the landowner is should the municipality set a cap in a major transit station area, which the landowner developer thinks is woefully inadequate to meet their expectations as to what they thought they could build on their property, you're out of luck as well.
The next couple of points we'll go through quickly as we're rapidly approaching the end of our session. The secondary plan two-year freeze builds on some of the two-year freezes from Bill 73. The thing we would note is the definition of secondary plan is incredibly broad. It's basically a set of policies that applies to something less than the entire municipality. So you have to be careful when your lands are being included within a secondary plan for whatever reason, that if you are in that secondary plan, that it prescribes the uses and heights and densities you want, because your ability to change that is going to be frozen unless, once again, unless you get council's permission to go ahead with an application. Interim control bylaws, currently there's an ability to appeal an ICBL as soon as it's passed. Under Bill 139 amendments, you're not going to be able to challenge ICBLs until a year has passed. And then the last is the ministerial zoning orders. This is part and parcel of the inability to appeal minister decisions. You're not able to appeal these zoning orders once they're imposed, which, as we say, is a real theme of Bill 139, which is that the province is the true final authority on local planning, or as Leo had said before we had started today, it's just a recognition of the province's role as it's always been, in the province's mind anyway.
Leading provincial policy has always been determinative in these matters, and since the province makes the laws, they like to make laws that say our decisions are final.
The next slide is on transition, which is obviously going to be very important for a lot of development proponents out there. The transition regulation is not final. What was posted online was a summary of a draft to give the idea of what the province is thinking for proposed transition. There was a commenting period that closed January 21st, so we are still awaiting the final word from the province on transition. But what we've set out in this slide is what we understand. It's not overly complicated. If you have appeals in front of the OMB right now, your appeal is safe. It'll stay at the OMB. If you filed a complete application before December 12th, which was the date of royal assent when the bill received its third reading, and you file your appeal before proclamation, which is the one date we don't know yet, your appeal will stay at the OMB. If you filed a complete application after December 12th, in other words, all complete applications filed from this point forward, your appeals are going to go to the LPAT after proclamation. And if you filed any appeals on decisions rendered after proclamation, you're going to go to the LPAT.
What the regulation did not state was situations such as the following. What if you have an appeal already at the OMB, and then you appeal a related matter under the new scheme and seek to consolidate those matters? Will the consolidated matters be considered under the legislative regime that existed at the time of the first appeal or not? People have submitted to the province that the regime of the first appeal should be the regime that deals with all subsequent and related matters to that. But the province has yet to indicate its position in that regard. Hopefully, the transition regulation will address that to remove doubt. If it does not, there are going to be some interesting submissions made to LPAT and perhaps requiring court determination to get a final ruling on those technical issues.
Now, the question we're most often asked when it comes to Bill 139 is, should I appeal? The advice we have been giving, or at least I have been giving clients, is yes. I say that because I can tell you what the OMB process entails. As I sit here today, I cannot tell you exactly what the LPAT process entails. And it's an issue of control over your own fate that would cause you to take a matter up to the board, even if you're making progress with the municipality. Now, that said, I would never discourage a client from continuing to engage with municipal staff and local council to try to come up with a resolution. You can always settle at the board or the tribunal. In fact, that's what they want you to do. But if you are in a position to appeal and you're wondering whether you should or you shouldn't, my advice thus far has been you should, if only to assert some form of control over the process moving forward. It may be that there is changes to come that would benefit you, but you're better off with the devil you know versus the devil you don't.
Now, this is our final slide, and one that, as Patrick has said a couple of times during this webinar, could be the subject of an entire presentation on its own. But let's quickly, in the time remaining, cover these off because I think they will address some of the questions that we have received today. Will council procedures change as a result of the new scheme? That's the million-dollar question. And places like the City of Toronto, I doubt it, with the amount of materials coming before that council. It's difficult to see how they might change their process. In smaller urban areas, rural areas, perhaps councils may be more willing to give an applicant and people speaking opposite more than 5 minutes in order to present their case. But let's be clear, there is no obligation tied anywhere in the legislative changes that would result in a municipality changing its process one iota. Patrick?
For complete applications, we touched upon that at the outset, that the emphasis is going to be on getting things in front of the municipality and getting them done the first time, that there might not be another chance. We foresee a need to engage probably legal counsel early on to help you vet your consultant's report and get them in a position where if your lawyer is ultimately going to have to stand in front of a tribunal member and argue an appeal case, that lawyer has had a chance to vet what is essentially going to be their evidence and know what they're going to be able to use and what they're not going to be able to use.
With respect to staff recommendation, are there more incentives now for proponents to work with staff to achieve a positive recommendation? Well, it's always been our advice to clients that that is the preferred route to go. I think these new regulations and legislative scheme will put to an end what was dying but still exist attitude of some applicants file an application, just wait the minimum statutory time period for appeal and appeal it to the board without wishing to engage staff or the municipal council at all. It seems now that in light of the restrictions that are placed on appeals, the timeline it takes to get to the tribunal, and the limited lens through which they will consider an appeal, working with staff and council is a reality.
With respect to appeal letters, there was already changes through Bill 73 to ensure that if you're going to raise issues of provincial policy, that you specify what are the policies that are going to be at issue. Now, with the new joint test and the new test, your appeal letters are going to have to specify how you think you meet those tests. And if you don't, the tribunal is empowered in the nature of a motion to dismiss to dispose of your appeal, because that is how the new appeal system is engaged, is in explaining in as clear as terms as possible how you meet those tests.
Dealing with the LPAT rules, as you see, they have not yet been published. So many of the questions have asked, well, if I'm a minor variance or a consent or a site plan, how does this affect me? The LPAT rules might indeed affect those applications as well by setting out how the tribunal may be dealing with those items. We just don't know. All we can tell you is that the legislation itself and the changes to the Planning Act and the creation of the new Tribunal Act don't specifically mention variances, consents, and site plans as having been within its crosshairs. But these new rules might address those matters, so stay tuned on those.
The LPAT Support Center, I believe, will be a very positive addition to the appeals process. The more informed and engaged persons can be when they arrive at the tribunal hearing, the better the process can run.
I think on the new tests we've already dealt that. Let's also be clear on other acts. There does not appear to be any changes to the OMB other than renaming it LPAT for the powers that the OMB, now new tribunal, will have under the Expropriations Act, the Development Charges Act, the Heritage Act, and others. Schedule 5 of Bill 139 amends all those other acts just to change the nomenclature from OMB to LPAT. But to our knowledge, all of those acts remain unchanged, and therefore the procedures that we've been discussing do not apply, as best we understand, to those processes and appeals under those other acts. And Patrick, you can take the final point.
Well, again, the final point could be its own webinar in and of itself, but suffice to say, if you're valuing land on its highest and best use, you have to really ask what is the ability to achieve that highest and best use, given that a number of avenues of appeal to achieve those highest and best use are now cut off, that certain areas are going to have prescribed policies that can't be amended absent cooperation from the municipality. So those who are valuing land have to ask themselves, what are the odds that a proponent is going to be able to get the municipal authority on side with a change that increases the value? Because if you can't, You can't go into the process expecting that there's going to be a tribunal to come to your rescue.
We'd like to thank, this brings to an end this webinar on Bill 139 and how it would affect your rights and interests. We appreciate your attention and interest in this matter, and thank all those who did submit questions that we have not had the time to respond to. It's clear that the interest in this matter is not waning. In fact, it seems to be growing, and perhaps we'll have another seminar once the regulations are actually published. So thank you again for your attention, and good morning.